Good morning, Mr. Harris. How are you?
Very well, very well. How are you?
That's good. Fine, thank you. Now, who have we got on the line? Sharla, you're there?
Hi, good morning, Your Honor. I apologize. I was on mute.
That's all right, Sharla. How are you? Now, Sharla, do we have everybody online that we're expecting? Mr. Harris, I don't know if you can help us with that.
Well, in the sense of our side,
in the sense of your team, yes.
yes, yes, we do. I see Mr. Roderick is on the line, as is Mr. Bailey from Allen & Overy. We have our witness, Yulia Zuzina, who is she's a double participant. She's sort of participated. Yes. She's got a video and a telephone feed if you're looking at the participant list. And we have Dr. Barr, who's our expert witness, on the line as well.
Good. All right. Thank you for that. Now, can I just ask online, is there any appearance on behalf of the defendant? No? All right. Well, I should more correctly say the third defendant. Charlotte, I wonder if you could either go yourself, but are you in the court building, Charlotte, in Dubai?
Yes, Your Honor, I am.
I wonder if you could either go yourself or send somebody out into the foyer of the court building and just ask if there is anybody there to represent His Excellency Saeed Mohammed Al-Kabasi.
Your Honor, that has already been done. We have not heard back from them. Right. I personally have emailed a couple times, no response. Not at all. Not even in regards to anything. The registry finance team, everyone has been trying to reach out with no.
And there's nobody in the building? Nobody in the courthouse?
Nobody in the building. No.
All right. All right. Thank you. All right. Well, that's fine then. All right. Well, I think we can get underway. Charlotte, would you like to read the usual introductory statement?
Yes, Your Honor. Thank you. This trial is in regards to case number CFI 060-2020 before Justice Wayne Martin. The claimant is represented by Allen & Overy LLP. Lead counsel is Mr. Christopher Harris, KC, instructed by Simon Roderick and Derek Bailey. The third defendant is not present.
Thank you. Mr. Harris, before I call on you, can I just put on record what I was just told by the court officer, and that is that attempts have been made to contact the third defendant, His Excellency Saeed Mohammed Al-Kabasi, by email and various other means, and none of those attempts have produced any response. And inquiries have been made in the precincts of the court building to ascertain whether there is anybody present to represent His Excellency in these proceedings, and nobody has been identified as being present. So, Mr. Harris, with that, over to you.
I'm very grateful, Your Honour. As you know, I appear for the claimants in this matter, as I have on previous occasions. This is, as Your Honour rightly said, the trial of the action against the third defendant. You should have received a skeleton argument.
I have, thank you, and I've read it and all the papers. And before we go any further, Mr. Harris, you have your witnesses present. I suppose against the remote contingency that somebody might have turned up and asked to cross-examine them, and that's not now going to happen. Do you want to call them anyway, or do you want to release them?
We do, on the basis that since we take the point that the third defendant not showing up and his expert not showing up means that their evidence is not of any weight, but more than that actually stands to be struck out.
Yes.
I would like to call them formally in due course, and then Your Honour can ask them any questions that you wish, and then they can be released in the usual way.
Yes. Well, Mr. Harris, I'm in your hands as to when you want to do that. I expect they've got other things that they would rather be doing, but that's entirely up to you.
Yes. Well, perhaps I can just outline what we'll be saying, yes, and then we can call them, and then we can take it from there. Yes. But I get the message from Your Honour that Your Honour's ready.
So I know it's hard for us to believe, Mr. Harris, but some people don't find discussions of the kind we're going to have terribly interesting and might want to be doing other things.
Yes. Well, perhaps the sensible thing to do then is with Your Honour's leave, if I rely on my skeleton argument as an oral opening as well as a written opening, and don't particularly open, we move to calling the witnesses, and then I can address any further points by way of submission in closing, theoretically.
Before you do that, just one question I want to raise in case you want to address it in the evidence, and that is there's provision in these security documents, as we know, for certificates to be issued to prove the amount of the indebtedness. Have you got a certificate proving that? How do you propose to prove the amount as at today? Are you going to do that by certificate, or is that done in the documents, or do you want somebody to give evidence of that, or how are you going to do that?
So what we have in terms of that, obviously the primary indebtedness hasn't moved since acceleration. What has been filed, and I believe you have to download it from the case lines file, is an updated schedule. You may recall at the last hearing.
Well, they're spreadsheets, they're Excel spreadsheets.
Indeed, that have been put in by Allen and Overy on that basis.
So all that's been done then, so in terms of you've taken this, the debt, the subject of the certificate, there's been no additional costs added in the quantity. I know you claim costs separately, but then you've simply calculated interest in the spreadsheets on that previously certified amount. Is that right?
That's correct. Yes, and it's
okay.
I can take you to the sheet in due course. And
no. That answers my question. Thank you for that.
So, well, perhaps then the next thing to do is for me to call Ms. Zuzina.
Yes.
And for her to take the oath and.
Yes. Yes, please.
Yes. So I call Julia Zuzina.
Yes.
Yes. You there, Ms. Zuzina? I wonder if you could turn your camera on so that we can see you.
I was trying to figure out how to do that because I see that a few features may not be available on this.
Charlotte, are you able to help us?
We have Mr. Adil from our IT team. Mr. Adil, can you please assist?
Would you like to call Dr. Barr now? Would that be a convenient?
Why don't I do that?
Yes.
Dr. Barr, could you switch your camera on, please? Thank you.
Dr. Barr, I'm going to swear you in.
Okay.
Okay, so I need you to raise your right hand, please, and let me know if you want to confirm. Please confirm with me if you want to swear or affirm today.
I'll swear.
You'll swear. Please have your right hand up. Do you have your holy book in front of you?
I do.
Thank you. So please state your full name and occupation for the record.
Dr. Catherine Barr, and I'm a forensic document examiner.
Thank you. So please repeat after me. I swear by the Almighty God.
I swear by the Almighty God.
To tell the truth.
To tell the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
Thank you.
Thank you, Dr. Barr. Mr. Harris.
Dr. Barr, you've given an expert report in these proceedings. Do you have a copy of that report in front of you?
I do, yes.
For the purposes of those using the case line system, it begins at D4 235. So I see a document headed Forensic Science Report with the case reference of this case and by Catherine Barr, MA, PhD on it, dated 22nd December 2021. Is that the document you have in front of you, Dr. Barr?
Yes, it is.
Dr. Barr, if you go on to what is in our online version, page 243, 164, and in your version, it is page, the internal page 9, perhaps. Is that your signature?
Yes.
And do you confirm that the opinions you have expressed in your expert report represent your true and complete professional opinion on the matters on which you've been asked to opine?
They do, yes.
I don't have any further questions for Dr. Barr. I don't know if you're on it, Ars.
Yes, I've just got a couple of questions, Dr. Barr. And firstly, thank you for making yourself available to us today. The thrust of your report is that based on the specimen signatures that you were given, you were unable to form any definite conclusion as to whether what I might call the contentious signatures were in fact made by the same person who signed the specimen signatures. Have I got the thrust of your evidence correct?
Yes.
And you've also assessed the reports prepared by Mr. Osborne, who's also a handwriting expert, and the difference between your view and Mr. Osborne's view, you believe, stems from the fact that you are given different specimen signatures by which to compare against the contentious signatures. Have I got that right?
Yeah, that's right.
Yeah, right. Well, that's all I had. Thank you, Dr. Barr. Mr. Harris, is there anything arising from the questions I've asked?
Well, perhaps I might just ask Dr. Barr, could you explain to His Honour what it is about the differences in the specimen signatures, in the signatures that you've been asked to look at, relative to those that Mr. Osborne's been asked to look at, that you think is important?
In essence, the ones I was asked to look at, which were all on notarized documents, are similar in shape. I think I've demonstrated that in the report to the ones that were on the contentious documents. And then by contrast, the ones that Mr. Osborne received were, again, they were all consistent within themselves, but differed to the ones on the contentious documents. Yeah. So since mine was similar, but I couldn't express, but because of the simplicity of the signature, I couldn't express any definite opinions. His were different, and obviously I didn't do the work for him, but I could understand why he would come to his conclusions based on the specimens that he saw.
Well, again, if I could just follow up from that, you were given only the only specimens you were given were notarized, and that's because of the greater confidence one can have in the fact that the person who made the specimen signature was, in fact, in this case, the third defendant. Is that's it? And
yes,
so
I mean,
there is the possibility that Mr. Osborne may have been given specimen signatures that weren't in fact signed by the third defendant.
In essence, yes. When we do a handwriting comparison, it's always, in effect, it's just a comparison of one set of signatures against another set of signatures, and we rely on the people providing them to say these are the specimens of whoever it may be. So if they're not, they're not. In essence, yeah.
Do you recall, Dr. Barr, what the date range was of the signatures that you looked at, and what the date range was of the signatures that Mr. Osborne looked at?
If I check my notes, I think mine were all around Mr. Osborne's. I definitely went from 2001 to the present. Mine were dated 2017 to 2019.
Yes, good. Yeah. Anything else, Mr. Harris?
No, nothing from me, Your Honour. Thank you.
Well, Dr. Barr, thank you. That completes your evidence. Thank you for your assistance. And Mr. Harris, there's no reason for Dr. Barr to stay on the line any longer, is there?
Not from my perspective. I'm grateful.
Well, thank you, Dr. Barr. You can go about your business. Thank you.
Thank you.
Now, we don't seem to have Ms. Sulina back on the line. Well, why don't you press on, Mr. Harris, and if and when she joins us visually, we can deal with her then.
Very well. So what I was going to say, by way of opening, was obviously the critical point to discuss before we get into any of the substance is the consequences of the third defendant's non-appearance. And you will have seen that I anticipated that that might be the case in my skeleton and tried to set out what we would say would be the result of that.
Yes.
Because we had seen that legal representatives came off the record in July of this year. There have after that been complete non-compliance with the court's directions in respect of disclosure and evidence prior to that. When they came off the record, they gave addresses for correspondence with the third defendant, which have been used since then by us. And it's right, as was said at the outset of this hearing, that the registry wrote to the third defendant by email last Friday and asked him if he was going to file anything before the hearing, and no response that we've seen was received. And then another chaser was sent on Monday, and again that was met by the registry, and that was met with silence. Now, as I identified in my skeleton, whilst it is right that the court has the power simply to strike out the defence and enter judgment as a consequence of the non-attendance, we do not invite you to exercise that power, and instead invite Your Honour to proceed with the trial in the absence of the third defendant. And so, as I explained earlier, I propose to call my witness and have her sworn when we can get her camera working, and the same as with the expert. In relation to the third defendant's witness statement, as I set out, under Rule 29.41, the third defendant is obliged, it's a must, call himself to give oral evidence, unless there is another from the court or a hearsay notice. There has been no application for any other order by the court, and there has been no hearsay notice served, either at the time of filing the evidence or since. And in those circumstances, the court is entitled to strike out his evidence. And I gave you the reference to the Daguerre capital investment case in that regard.
Yes.
We also say that further or alternatively to that, by Rule 29.12, because any fact which needs to be proved by witness evidence is to be proved by oral evidence in a trial context as opposed to an application context, the third defendant's absence means that there is in fact no factual evidence in support of his case beyond the documents, which is before the court. And since his case rests entirely or almost entirely as a factual matter on his assertion that he didn't sign, that is fatal for his case.
And you put the same submission, sorry, in relation to Part 29, Rule 41, you put the same submission in relation to Mr. Osborne, I assume?
Yes, his 2941. Yes, he's got to be called to give evidence, and he has.
So Mr. Osborne has to be called, and he's not here. So
yes, and ditto to the extent that that evidence would need to be given orally, or at least adduced orally, in order to count a trial. So his evidence doesn't count. But as I say, in relation to both of them, even if you weren't with me on either of those points, you should certainly not give their evidence any weight.
Well, I agree entirely, Mr. Harris. I am with you. I think you're. I agree that the effect of those rules is that the evidence is not admissible, and so I won't receive it. But in case an argument is mounted to the contrary, if I had formed a different view and received the evidence, I wouldn't have given it any weight because of your inability to test it through cross-examination. So the practical result is, I think, pretty much the same, whichever way you look at it.
Yes, well, I'm grateful for that information, Your Honour. So in terms of the substance then, Your Honour will recall that you've seen this this case before.
Yes.
And
It keeps on coming back like a bad penny, Mr. Harris. I'm hoping this might be the end of it.
Well, yes, we hope that too. You will recall that on the last occasion I was before you, at the end of last year, you granted our application for immediate judgment, and that immediate judgment was to dismiss the second and third defendants' challenges to the court's jurisdiction, to grant our claims and dismiss the defences of the first, second, and fourth to 18 defendants, i.e. all of the defendants apart from D3. And the only thing that was left over was the third defendant's defence. And that was left over because, as I explained to you on that occasion, we took the view that since he had filed the expert evidence, that was a matter only suitable to be addressed at trial. So that was all that was left over. The court made directions. As I said a moment ago, those directions weren't followed. We made document production requests. They were not responded to at all. And no further evidence was filed by the third defendant.
Yes.
Now, what you have, therefore, as you know, is a claim to enforce repayment of very substantial syndicated lending by the claimants to the first defendant, which lending was guaranteed by the other defendants. You've already found that it was guaranteed by the second and fourth to 18th defendants. The question today for the court is whether it was also guaranteed by the third defendant. We say it was, and we have shown you and referred you to the two personal guarantees which the third defendant entered into in respect of the first defendant's indebtedness. I'm happy to take you to them now. If you'd like to see them.
I've looked at them again. I've seen the signatures and compared them to the other materials.
And of course, as you know, the third defendant's case is that he didn't sign them. We say that is not true and not remotely credible. And we rely on a number of matters in that regard, a number of which Your Honour has already found to be established in relation to the second defendant, and generally in your immediate judgment, and the reasons for that, which you gave, I think, on the 6th of December 2021, paragraph 27. You say, in this regard, claimants rely upon the following matters, all of which are established on the evidence before the court. And we invite you to, consistently with that, find that those same matters are established. And in particular, the first one, the fact that although the second and third defendants assert they were not aware of the existence of the guarantees until they were shown them in the course of these proceedings, there's clear evidence to the contrary, including one, the report of the board of directors of the first defendant for the year ending 31 December 2018, which is a board in which they were both serving, which attached the consolidated audited financial statements in which the loans and the personal guarantees were expressly referred to, and also that each of those defendants, and in particular for our purposes today, the third defendant, was given notice of the claims based on the guarantees prior to the commencement of the litigation. So that is important, we say, and it's important in two senses. One, because it undermines the credibility of the argument being made by the third defendant that these matters were entered into without his knowledge, these guarantees. But also, as you'll have seen from our defence, our reply, to the third defendant's defence, we said that even if the third defendant was able to satisfy you, even if he testified and he'd been able to satisfy you that he didn't personally sign the guarantees, we said that wouldn't assist him, because it would be to be inferred that he had authorised someone else to apply his signature and thereby agreed to be bound And that inference, we say, arises from the fact that the third defendant was plainly aware of the existence of the personal guarantees. We pleaded this out and the reasons for it in paragraphs 7.1 to 7.5 of our reply. Yet the third defendant did not raise any issue as to the validity of those guarantees until after this litigation was begun. And we explained in the skeleton that the court would expect anybody who just learned that they had a personal guarantee for over $300 million to be that they hadn't signed and were not aware of, to raise that point fairly quickly and probably in fairly strident terms. And the fact that there was absolute silence for several years is a complete answer. But for the same reasons, and in another further alternative, even if the third defendant hadn't given prior authorization for his signature to be applied in this hypothesis, he ratified the signature by some third party by his conduct in not questioning its validity. So those are the additional reasons why we say that it's particularly important, those findings that you've made, that they, despite their claims, the third defendant knew about the existence of the guarantees. So that's the first point. The second point is obviously, and there's no getting away from it, we've got the fact that the guarantees were both supported by certificates provided by a partner at Latham & Watkins in London, confirming that he had been appointed by the second and third defendants to provide them with independent legal advice on the guarantees, and that he had done so. And whatever one may think about the separate confirmations that were signed by the third defendant confirming that he had received that advice, whatever he may say about his signature on those, it is something that would require, in my submission, very serious evidence for this court to find that those certificates provided by a partner at Latham & Watkins in London were untrue. And at the very least, it would have been incumbent upon the third defendant to call or reduce evidence from that partner if it was going to be said that the person who was theoretically his lawyer had not actually given him that advice. And there's nothing of the sort. And we relied on various other matters, as you can see, in that you refer to in paragraph 27 of your immediate judgment.
Yes, and you've summarised them, I think, in paragraph 29 of your skeleton. No, that's not 29. It's yes, it's 20. It's 32 of your skeleton. 32.
Yeah.
Yes.
And there's an overarching implausibility to the case that's being brought, only made worse by the third defendant's expansion, if you like, of the allegation that he now asserts that there's some wider conspiracy that involves multiple different verticals of companies in which he was involved and multiple different management groups, all apparently simultaneously forging his signature on a variety of guarantees that provided vast sums of lending to companies in which he was interested. And that is made all the more clear by the evidence that we've adduced with the second witness statement of Ms. Zuzina, which you may have seen is the only new evidence from our side with Dr. Barr's report post the immediate judgment. And I've tried to summarise it very shortly in paragraph 33, but Ms. Zuzina goes through it quite carefully. In essence, what she's been able to piece together is a number of other facilities in excess of $2 billion in value that were granted to corporate bodies in which the third defendant is interested, in each case of which the third defendant has given a personal guarantee. In each case in which Credit Suisse adopted its standard practice of requiring a certificate of independent legal advice, which were provided by partners of Latham and Watkins, including partners other than Mr. Chesterman, who's the partner in this case. So the third defendant's allegation is if he were to deny these guarantees, which he doesn't currently, but if he were to, it would have to be that more than one partner of Latham and Watkins in London is producing false statements of legal advice. And I referred you to one of them in the skeleton just as an example.
Yeah.
But it's important that the third defendant hasn't denied the validity of his signature on any of those personal guarantees. So you have an established practice whereby vast lending has been procured. There's always the same approach taken with the provision of independent legal advice, with the signature of confirmation of receipt, and the third defendant giving these guarantees. And that just further reinforces the inherent implausibility of his assertion that this is all news to him, and he just didn't give these guarantees, and they were all given by some massive conspiracy amongst multiple different people. So for those reasons, we say the third defendant's case after the immediate judgment hearing, based on the additional evidence, has got worse, not better. The only thing he had that got him to trial was Mr. Osborne's evidence, and the fact that that would need to be explored at trial. As we've already explored, he hasn't produced Mr. Osborne, so that evidence has no weight. But in my submission, even if he had, Mr. Osborne's evidence doesn't take you anywhere, because Dr. Barr's more careful evidence is certainly to be preferred. Dr. Barr's evidence is based on notarized signatures, which are contemporaneous with the disputed signatures. Mr. Osborne's analysis is largely, if not exclusively, but largely unnotarized signatures from a 20-year period, which necessarily makes them less homogeneous and less important as a tool of analysis. And you have a position where, based on the material he's looked at, Mr. Osborne has apparently formed fairly strong views, but he hasn't come here to defend them. Dr. Barr, despite having notarized signatures which he finds are highly similar to the disputed signatures, and despite having microscopically analysed the wet ink signatures on the documents, which she has said are do not display evidence of the usual things that one sees.
Something strange going on.
There's nothing better than hearing yourself.
All right, I think normal transmission has been resumed, Mr. Harris, so you can continue.
Yes, I'll finish that point then. So
yeah.
what we would say is that Dr. Barr has looked at contemporaneous signatures. She's looked at the wet ink signatures microscopically and seen that she doesn't see the pen removal or anything of that nature which might indicate that the signature has been copied. She says that in her report, and that the signatures are smooth. But because she says the signature just is a relatively simple form, she's not able to, being a careful expert, she doesn't feel able to tell this court that she can be absolutely certain that these are not forged. So she says, in effect, the court isn't really assisted by expert evidence on this, because the experts can't properly form a clear view on it. And it's right to say Mr. Osborne identifies the simplicity of the signature as what he calls a limiting factor, but he doesn't factor that in to his conclusion in my submission. It's one of the things that we'd have tested with him in evidence, that it is probable that these signatures are a forgery. So that's the long and short of it is the expert evidence, which is the only thing that got the third defendant to trial, falls away because he hasn't shown up. But even if it didn't, Mr. Osborne's expert evidence is not credible. And
please hold.
And Dr. Barr's would have been to be preferred as far more measured. But the upshot of her evidence is that the expert evidence doesn't really advance
Yes.
the position for the court. So
So
that
what
leaves
we're
us
left with then is a defence which makes allegations but no evidence to support it, and all the evidence on the other side of the ledger that you've taken me to.
a defence which makes serious but rather generalised allegations of dishonesty and corruption against persons unknown, but which where there's no evidence, as Your Honour rightly says, to support that, and all the evidence on the other side to support our case. So that for those reasons, we would invite Your Honour to conclude that the defence is not made out and that our claim is made out.
Yes.
But we need to get, obviously, Ms. Zuzina on the
Yes.
screen.
What should we do? Is there anything else you want to say before we do that? I must say I've read all the papers thoroughly, and I'm with you, Mr. Harris, in relation to all of the points you make in your very helpful skeleton, and I think the evidence is there. I've just got a couple of questions, perhaps while we're waiting for the technological issues, and that is in terms of the judgment. The amount for which you want judgment entered is, I believe, $348,751,608.59, and that's from your skeleton and also from the spreadsheet.
Yes.
But do you want a judgment in that single sum? There is a breakdown in your in paragraph 29 of the skeleton showing the amounts due to each of the claimants. Do you want separate judgments or a single judgment in favour of all?
A single judgment.
Right. Okay.
Which is also what we did on the last occasion. This is the same table that I gave you in my skeleton last time, updated with the interest.
Right. Okay. Well, there'll be a single judgment then in favour of all claimants. And then there's that outstanding question of interest from today, whether you want it the judgment rate or the contract rate. So
yes, and my instructions on that are interest at the judgment rate is satisfactory.
Good. Okay.
There is the only other thing feels I'm not sure now is the right moment to do it. I'll have to explain to you a little bit what we're proposing in terms of costs if we get there and when we get there.
Yes.
Because there's obviously a measure of complexity to that.
Should we just break briefly while you try and, or those who instruct you, try and contact Ms. Zuzina and see what's going on? Is that the best thing? Well, why don't we just break for? Let's come back on the hour, by which time you and your instructors might have been able to make contact with her and find out what's going on. So we'll resume on the hour then, whatever the hour is, wherever you are, Mr. Harris. Pretty early in the morning, I expect. So
correct.
All right.
I can only apologise, Your Honour, for the
no. These things, it's certainly not your fault. These things, the technology is great when it works, but it doesn't always work. All right, we'll resume on the hour then. Thank you. I think everybody just leave the lines open and just turn off cameras and microphones, and we'll resume it on the hour.
And again, apologies for the time.
No, these things happen. That's fine. Mr. Harris, would you like to call Ms. Zuzina?
I would indeed, Your Honour, yes. So I call Julia Zuzina.
Charlotte, are you there?
Yes, Your Honor.
Good, thank you.
Would you please state your full name and occupation for the record?
Sure. My name is Julia Zuzina. I'm structural within Credit Suisse.
Will you be swearing or affirming today?
Swearing.
Swearing. Do you have your holy book with you?
Give me a moment. I will in a moment. Yes, I'm back here.
Thank you. So please repeat after me. I swear by the Almighty God
I swear by the Almighty God
to tell the truth,
to tell the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you.
Thank you, Mr. Zena. Mr. Harris.
Mrs. Zena, you've given two witness statements in these proceedings. I'd just like to take you to them and get you to confirm those statements. Have you got your witness statements in front of you?
I do, yes.
For our purposes, we have a hearing bundle, and the first statement is at C4 at page 56. And if you go on in that to what is in our bundle, do you see, you have a witness statement that says first witness statement of Julius Uzina in front of you? Do you have that one? Mrs. Uzina? Do you have the?
Yes, the first one.
Yeah, the first one that says it's witness statement of first witness statement of Julius Uzina. And if you go on to the 8th page, the final page of it, which is, I think, page 63 in the electronic bundle, and it's dated the 21st of October 2020, yes? Is that your signature?
It is.
And do you confirm that the facts stated in this witness statement are true?
I do confirm.
And then, if you can take your second statement, please. And that is at bundle for those online is C4 page 1127. And if you go on, Mrs. Lina, to the 5th page of that document, it's dated the 10th of August 2022, yes?
Yes.
And is that your second witness statement?
It is.
Is that your signature on the 5th page?
Yes.
Which is 1131 in the electronic bundle. And do you confirm that the facts that you stated in that witness statement are true?
Yes.
Thank you, Mr. Zena. I don't have any questions for you, but His Honour may.
Well, Mr. Zena, I hope you're not disappointed after all the trouble we've put you through to give that evidence, but I don't have any questions for you. So thank you for your assistance. It is, as a matter of formality, it is important that you have given this evidence. So thank you for going to the trouble of doing so. What you do now is entirely up to you. If you'd like to stay and watch the rest of the proceedings, you're perfectly free to do so, but there's no compulsion for you to remain. And perhaps if you could turn the camera off, that would be good. All right. Thank you.
Thank you, Your Honour.
Thank you. Now, Mr. Harris, back to you.
So, as I was saying before, Mrs. Zena's evidence, subject to any other questions that Your Honour has for me, our evidence, both documentary and witness evidence, is now before you. It is unchallenged. And in my submission, our case is made out, and I invite you to give judgment.
Yes, well, I've gone through the material. Thank you, Mr. Harrison. With the assistance of your helpful skeleton, I've reviewed all the material carefully, and I agree. What I propose to do is I'll pronounce judgment today, but I would, rather than expose you to the tedium of having to watch me struggle through an extempore judgment, what I will do is I'll make orders today, but for reasons to be published in due course, and I'll publish those reasons in due course, in which I can give a fuller analysis, just in case there is ever any challenge to the judgment. But the amount that the judgment will be for the amount of $348,751,659 and that's in 59 cents, and that's in US dollars. We're interested in 9%, and now I think you want to talk to me about costs.
Indeed, yes. So at the last hearing, Your Honour made an order for costs, which obviously part of that was
Yes.
related to the jurisdiction application of the third defendant. And there is obviously a large amount of overlap because all the defendants are liable for the overall costs. So what we
Yes.
sought to do is to give credit for that, and we file the costs schedule.
Yes.
I'm not sure if
I've
if
seen
you've
that.
seen
I've got it in front of me.
Very good. Well, can I just explain to you where those numbers come from, and just for your note, in case you haven't got that in front of you. On the last occasion, the judgment was for $329 million odd, and the costs order was for $633,285. I think, Mrs. Zena, you're not on mute. You may want to put yourself on mute. So I'm hearing an echo. That's better. It was 633,285 spot 69 of costs. So what we've tried to do, those costs comprised all of the fees from June 2020, the start of the proceedings, through to November 2021 for A&O counsel fees and the first tranche of the DIFC filing fee. But no cost order at that stage was made in respect of the third defendant. And we seek those costs now.
Yes.
Obviously, all costs in the proceedings until the filing of the application for immediate judgment were incurred equally against all the defendants, and they're jointly and severally liable for them. There is some nominal time spent examining the first and 4th to 18th defendants' defences, which were slightly different from the guarantor's defences. As you'll recall, they had some spurious defences of their own. But we didn't file any reply to that defence. We just applied for immediate judgment, so those costs were relatively limited. We have effectively discounted our costs by 5% to reflect the time spent dealing with, specifically with D1 and D4 to D18's defences. So we asked that the third defendant pay 95% of those costs, those basic costs, prior to the issue of the immediate judgment application on a joint and several basis with the other defendants. That gives a figure of $359,000 for that period, June 2020 to September 2021. We've then got a filing fee of $46,000, which is
so that figure of 359. Sorry, Mr. Harris, that figure of 359,000. That's the figure in your statement of costs, is it? That's the 359,484.05 cents.
Yes.
So that's joint and several with the previous cost order that I've made. Then is it?
Indeed.
Yes. All right. Good.
And then you have let me get. I just want to get it up on my screen as well. Make sure we're looking at the same thing. So then we have the period up to the immediate judgment hearing. So from September 2021 to November 2021, the immediate judgment application. Yeah. The cost of that application, we have effectively apportioned 10% of the costs of the immediate judgment application to the third defendant. We claimed a total of $144,000 in Allen and Overy's fees for that period, 60,000 of council fees and 5,000 of disbursements, and we've applied a 10% figure to that. So that brings out effectively just over 21,100 for the immediate judgment application aspect for D3 that we're asking D3 to bear.
Yes.
And then obviously since then, so that means that our total claim for the immediate judgment phase up to immediate judgment against the third defendant together with the others is 425,900.
Yes. And that again is joint and several with the 633.
Indeed, yes. So he's liable effectively for 400. He's jointly and severally liable for 425.9 thousand of the 633,000 that you awarded last time.
Yes.
And it may be that it's simplest to make two different cost orders to make this clear.
Yes.
The second stage is then from that the date of that immediate judgment through to trial, when it's only Mr. Gavesi, the third defendant, who's involved, and the total fee for that period is $359,000.
That's the same amount. That's a different 359,000.
It is, yes. It looks.
I see. All right.
It's curious.
Okay, so you want an additional 359,484 in respect of work done since the dismissal of the jurisdiction applications up into the trial, and
Correct.
that covers the preparation for the trial.
Correct.
Yes. All right.
And that's just against. And those figures break down as 280,000 more or less, 279,000 of Allen and Overy's fees, and £80,000 of the disbursements.
Yes. All right. Well, I see no reason to doubt the rates or the times spent. And the reality is, when judgment is being entered for 348 million, this is probably not going to make a great deal of difference to the defendant. But of course, I wonder if I should look. Is there any point in reserving liberty to apply in respect to these costs? I can't see any rule. Do you think it should be a good idea?
Well, we did that on the last occasion.
Yes. Well, I will reserve. So the orders you seek then in relation to costs are that the third defendant be ordered to pay $425,900 in respect of costs up until the dismissal of the objection to jurisdiction, that amount being he being liable for that amount jointly and severally with all other defendants. And then you seek an order that he, in addition, he pay a further $359,484.05 in respect of costs for which he alone is liable.
That's right.
That's it. Right.
On the first one, it's important to be clear that 425,000 forms part of the 633,000 already ordered. It's not supplemental to.
Yes. Yes. All right.
If it's an assistance, and then so the draft order we were proposing had a third paragraph which had that the third defendant shall have liberty to apply no later than 4 p.m. on the 10th of November for the cost order to be paid to be assessed by the court rather than fixed.
Yes.
I'm happy to provide Your Honour with a.
Is there a draft order? Is there? Have you got a draft order there? I don't think.
It may not have made it.
Seen that.
But we can provide that now if that's of assistance, Your Honour.
Yes. Could somebody email that around? That would be helpful, I think.
Yeah.
Perhaps let me give you my direct email if I can for those who are listening in. My email is wsmartin, or lowercase 36@gmail.com. If you'd include me and send it to the court and copy to me, that would be helpful.
But it tracks what we've just said.
Good.
broadly. Mr. Bailey's probably sending that over as we
Good.
speak.
What? I'll just go and find my phone. It sometimes comes through quicker on that. Just bear with me.
I understand it's just been sent.
Good, thank you.
Receive it shortly. Just popped up on my screen, Your Honour. I don't know whether that means it might have popped up on yours.
Yes, it has on mine as well. Thank you. That's great. Let me open it. Well, those orders look entirely fine to me. As I say, what I'll do this time, instead of struggling through an oral judgment, what I will do is I'll go away and produce something in due course, and there can be reasons published later. So the order can simply say, for reasons to be published in due course, it is ordered that. And so, Mr. Harrison, I can formally pronounce those orders now, unless there's anything more you want to say.
No, I noticed a couple of typos, and obviously the date of the hearing will need to be adjusted and things like that. But that's something that the registry can deal with afterwards.
Yes, indeed.
Nothing further from me, Your Honour.
Well, the orders I'll pronounce then are that for reasons that will be published in due course, I'm satisfied that the claimant's case has been made out against the third defendant and the judgment should be entered. So judgment will be entered against the third defendant in the sum of $348,751,608 There'll be another order that the third defendant shall pay the claimant's costs of the claim, A, through to immediate judgment entered on 30 November 2021, jointly and severally with the other defendants, fixed in the sum of $425,900, and secondly, from the entry of immediate judgment through to trial, fixed in the sum of $359,484.05. And there'll be a third order that the third defendant have liberty to apply no later than 4 p.m. on 10 November 2022 for the costs ordered to be paid in paragraph 2 of in the second order that I just announced, to be assessed by the court rather than fixed. Is there anything else, Mr. Harris?
Can I just clarify, Your Honour? I think you just misspoke on paragraph 1 of the order. You said 348,000, and it's obviously 348.
Oh, sorry, 300. Yes, I did. That would have been disastrous. 348. What I meant to say in order 1 is $348,751,608.59.
Very grateful.
All right. Nothing else?
Nothing else from my side.
All right. Well, thank you very much, Mr. Harris. Charlotte, can you please prepare a draft order? Oh, the other thing that needs to be in the order is order 4 will be the judgment will bear interest at the judgment rate of 9% from the date of judgment, which is today's date. So, Charlotte, could you please prepare an order in those terms and send it through for me to review? And the order will take effect as of today.
Yes, Your Honour, will do.
Good, thank you. And Charlotte, have you got a copy of that draft order that's just gone around? Has that gone to you as well?
Yes, Your Honour, I just received it, yes.
Excellent. Okay, good. All right. Well, thank you very much, everybody, for all the assistance you've been in the course of this hearing. And that concludes the hearing. Thank you. Goodbye.